In the case of circumvention of anti-dumping duty imposed on the article, the central government may extend the anti-dumping duty to such an article or article oriented to export to such country. The central government on such inquiry, it may be considered necessary in the opinion that circumventing the anti-dumping duty has been taken place by either of the following way: by altering the description of the name, composition of the article subject to the anti-dumping duty, by the inputs the article is unassembled and disassembled form, by changing the country of origin or export or any other manner whereby anti-dumping duty so imposed is regarded to ineffective. It may extend the anti-dumping duty to such an article or article oriented in export from the country in the case may be from such date not earlier than the date of initiation of the inquiry as may be specified by central government by notified by the official gazette section 1 year. Absorption of anti-dumping duty. Absorption of anti-dumping duty is said to have taken place if there is some decrease in the export price of article without any consummate change in the cost of production of such article or extent price of articles to countries other than India or real estate price in India or such article imported from the exporting country or territory. Such other circumstances as may be provided by rules. Whereas central government on such inquiry as it considered necessary is of the opinion that absorption of anti-dumping duty has taken place whereby the anti-dumping duty is so imposed on rendering ineffective. It may modify such duty of counter of the effect of such absorption for such date not earlier than the date of initiation of inquiry as may be specified by the central government by way of notification and official gazette. Provisional lab anti-dumping duty when the determination of normal value of margin of dumping in relating to any articles in accordance with the section of rules that may be under the pending. Central government may impose anti-dumping duty on the basis of providing estimate of such value of margin. If the provisional duty is higher than the marginal finally determined, then the central government may reduce anti-dumping duty so can refund the excess duty collected. Non-applicability of anti-dumping duty. The anti-dumping duty shall not apply to the articles imported by the 100% UAE or the unit of SEZ unless it is specifically made applicable to such notification to such undertaking or unit. Such article is neither cleared or such into DTA and used in the manufacture of any goods or clearance into DTA. In such case, anti-dumping duty shall be imposed on the portion of the article so cleared to and as applicable it will be imposed in the article. For the purpose of such section, the expression 100% UV shall have same meaning as assigned in the clause 1 of section 2 of section 1 of the section 3 sorry explanation 2 clause 1 to section 3 subsection 1 of the Central Excise Act 1944. The expression the social economic zone shall have been same meaning assigned to the clause EZA in section 2 of the special economic zone 2005. Imposition of duty in retrospective effect. The following conditions that are satisfied central government may be notification official gazette leave anti-dumping duty retrospective from the date prior to the date of imposition of anti-dumping duty. Notwithstanding anything contained in the law on the time being in force, such duty shall be leviable at such a rate and from such date and may be specified in notification. Retrospective date for which the duty is payable shall not be beyond 90 days from the date of such notification. There is a history of dumping which causes injury on or the importer was should have been aware of the exporter practices dumping and that dumping should cause injury. Injury caused by massive dumping of article imported in a relatively short time, which is a light of time and volume of imported articles dumped, and the circumstances likely to seriously determine the remedial effect of the anti-dumping duties liable for the leave. Duty ceases to have effect on expiry of 5 years. Anti-dumping duty imposed under the section shall, unless revoked earlier, cause to have effect on the either 5 years from the date of imposition. Duration is 5 years, extend up to 5 years. However, central government has reviewed the opinion that the cessation of the case is likely to lead to continuation of recreation of dumping and injury. It may from time to time extend the period of which imposition for the further period of 5 years, and such further period shall commence from the date of the order's extension. Further, when the review initiated before the expiry of a faucet period of 5 years has not come to the conclusion, before such expiry, the anti-dumping duty may continue to remain in force. Pending the outcome of such review, for the review period not less than 1 year. However, if the said duty is revoked temporarily, the period of the revocation cannot be extended 1 year at a time. Rules relating to anti-dumping duty. The central government will determine ascertain the margin of dumping and referred in the subsection 1 or subsection 2 of the time of carrying out the necessary inquiry. Central government by notification in official gazette make rules for the purpose of the section and without prejudice to the generality of the foregoing such rules, they provide for the matter in which article liable for anti-dumping duty may be identified in which the export price, the normal value, margin of dumping in relation to such article may be determined. For the assignment and collection of such anti-dumping duty, subsection 6, records for the furnishing determining the margin of dumping. The margin of dumping related to the article exported by the exporter and product producer under the inquiry of subsection 6 shall be determined on the basis of record concerning normal value and the export price method. The information provided of such exporter or producer. However, the exporter of the produce fails to provide such records, information, or margin of dumping of such export or produce shall be determined on the basis of fact available. Refund of anti-dumping duty. Section 9A provides that whereupon determination upon the officer authorized in behalf of the central government under subclass 2 of subsection 2, importer proves that satisfying the central government that he has paid anti-dumping duty imposed under section 1 of section 9A of article in excess of the actual margin of dumping in relation to this article, the central government shall as soon as may be reduce such anti-dumping duty as in excess of the actual margin of dumping so determined relating to such article or such importer shall be entitled to refund such excess duty. Illustration 2. What will be the date of commencement of the effective anti-dumping duty in the following cases under section 9 of Customs Tariff Act and the rules made therein, where no provision of duty is imposed, the provision of duty is imposed, where the anti-dumping duty is imposed retrospectively from the date period of the date of imposition of provision duty. Central government has the power to levy anti-dumping duty on the dumping articles in accordance with the provision of Section 9A of Customs Tariff Act 1975 and the rules framed thereunder. In the case where no provision duty is imposed, the date of commencement of anti-dumping duty will be the date of publication of the notification and imposed anti-dumping duty under Section 9A of official gazette. In the case of provisional duty is imposed of Section 9(2)(a), the date of commencement of anti-dumping duty will be the date of commencement of notification and imposition provided under Section 9(2)(a) in the official gazette. In the case of anti-dumping duty is imposed respectively under Section 9(a)(3) for the time period to the date of imposition of provisional duty. The commencement of anti-dumping duty will be such a prior date as may be notified in the notification imposition of anti-dumping duty retrospectively and is not beyond 90 days from the date of such notification provisional date. No levy under Section 9 or Section 9A in certain cases. Section 9B of Customs Tariff Act. The provision of the section provides that notwithstanding anything contained in Section 9A, Section 9A or 9A, no article will be subject to both countervailing and anti-dumping duty to compensate for the same situation of dumping and exporting subsidized. Countervailing duty and anti-dumping duties must not be levied such because such articles are exempted from duties or taxes borne by this article when meant for consumption in the country of origin or exportation by reason the refund of duties or taxes. These duties shall not be levied on the importation of goods members country of WTO or the country which whom GI holds most favored nation agreement unless determined has made the import of such article into Italy causes threats material injure on the established industry in India or material retract the establishment of any industry in India. The provision countervailing anti-dumping duty shall not be levied on any of the provision importer for the specified countries unless a preliminary finding has been made. The provision of countervailing duty and anti-dumping duty shall not be levied on any trade article from a specified country unless a preliminary finding has been made on subsidy of some dumping and subsequent injuries of domestic industry, and further determination has also been made the duty is necessary to prevent the injuries being caused during the intervention. Point B, C, D mentioned above shall not be applicable in the case where the countervailing anti-dumping duty has been imposed on the article to prevent injury, threat of injury to domestic industry, third country exports like articles of India. Illustration 3. The reference to the Customs Tariff Act 1975 discussed the validation of imposition of customs duties in following cases. Both the countervailing duties and anti-dumping duties has been imposed on article to compensate for sanitation. It's not what Section 9B of Customs Tariff Act. No article shall be subject to both countervailing and anti-dumping duties to compensate for the same situation of dumping or export subsidization. Countervailing duty has been levied on the article for a reason that the same is exempt from the duty borne by the like article when meant for consumption in the country of origin. It's not valid. As Section 9B Customs Tariff Act 1975, countervailing of anti-dumping duty shall not be levied on the reason for exemption of such articles of duties or tax borne by the like articles when meant for consumption in the country of origin or exportation for the recent refund of the duties or taxes. Defined anti-dumping duty has been defined anti-dumping duty has been levied on the article imposed for the member of country of World Trade Organization as determined have been made in the prescribed manner for import of article into the India threatens material injury to the indigenous industries. Right. As per Section 9B of Customs Tariff Act, no definition of countervailing duty or anti-dumping duty shall be levied on the import into India of any article from the member of the country of the World Trade Organization or from any country from whom Government of India has most favored nation agreement. Unless determination has been made the prescribed manner, the import of such article into India causes threats, material injury to any established trade in India, or material retreats the establishment of industry in India. Appeal. Section 9C of the Customs Tariff Act. The provision of Section 9C of Customs Tariff Act enumerates the order against each appeal on a preferred customs and excise service tax appeal tribunal, CESTAT. The procedure of timing limit of this resultant manner is filled in appeal of addressing to this action. An appeal against order as determined in the review thereof shall lie to the CST constitute on Section 129 of Customs Tariff Act, Customs Act 1962, in respect of existence of decree and effective and subsidy or dumping in relation to the imports of the articles or import of such articles into India in such increased quantity and under such condition as the cause of threatening of such serious injuries to domestic industry requires imposition of safeguard duty. In relating to the import of such article, an appeal filed under the section shall be accompanied by a fee of 15,000 every application before the CESTAT. In the appeal of the grant of stay for rectification of mistake or for any other purpose, the restoration of appeal or application can be accomplished by a fee of 500. Every appeal under the section shall be filed within 90 days from the date of order under the appeal. However, the appellant tribunal may entertain any appeal after the expiry of the 90 days. It is satisfied that the appeal was prevented by sufficient cause for filing the appeal in time. The appellant tribunal may, after giving the parties to the appeal an opportunity of being heard, pass under the order thereon as it thinks fit, confirming, modifying, and annulating the order appealed against. A social welfare surcharge on the important goods. A social welfare surcharge, SWS, 10% is levy on the levy of education such for those providing and financing education, health, and society security. SW is leviable on aggregate of duties, taxes, and cesses leave on the goods or as per Section 12 of Customs Tax, that is 10% of PCD. 1962 was the case. Some chargeable on the article under the law of time being enforced in addition to and the same manner as a duty of customs. However, the following duty shall be excluded of the customs this act. Safeguard measures under Section 8B of Customs Tariff Act, countervailing duty under Section 9 of Customs Tariff Act, anti-dumping duty under Section 9A of Customs Tariff Act, and social welfare surcharge itself on importation of goods. Social welfare surcharge on imported goods are in addition to any other duties of Customs Act or cess chargeable on the goods under the Customs Act 1962 or any other law time being enforced. The provision of the Customs Act 1962, the rules and regulations made therein, including the relation to assessment, non-levy, short levy, refund, exemption, interest, appeal, offences, penalties, shall apply in relation to levy and collection of social welfare surcharge in the importation of goods as they apply in relation to the levy and collection of duties, customs, and that's the goods. A similar term SWS capped of 10% of BCD levied and collected on the goods imported in India. The social welfare charges levied on the inter tax and goods service and compensation has been exempted via notification 13 2018 dated see 2nd February 2018. Agriculture, infrastructure, and development cess on the importation of certain items. Agriculture, infrastructure, and development cess has been levied on the import of specified goods on a specified rate. For instance, some of the notified goods are like apples, kubuli, chana, various type of coals, urea, silver, including imported by eligible passengers, silver, door, gold, including imports of eligible passenger, gold, door, etc. Which is this is used in financing improvement of agriculture infrastructure and other development experiment. The duty is levied on the goods on the percentage of the value when the purpose of calculation EAIDC. Value of the goods is calculated in the same manner as the value of goods is calculated in the purpose of Customs Duty Section 14 of Customs Act 1962. AIDC is important goods in addition to any other duties or custom chargeable on such goods under the Customs Act 1962 or any other law of the time it was. The provision of Customs Act 1962 and the rules and regulations made thereunder, including a relation to the assessment, non-levy, short levy, refund, exemption, interest, appeal, offences, penalties shall apply in relation to the levy collection of AIDC and imported goods as the applicable apply in relation to the levy collection of duty and customs on such goods under the Act or the rules and regulations as the case may be. Example of the goods in which AIDC is imposed have been given here under only for the knowledge for the students and these are not allowed for examination purpose. Let us recapitulate basic customs duty BCD section 12 of the Customs Act 19 and section 2 of Customs Tariff Act CT. BCD is levied under section 12 of the Customs Act on the goods exported from India on the goods imported into India. Rates of BCD section 2 of Customs Tariff Act first schedule and second schedule. First schedule rate of duty on the imported goods, second schedule rate and duty of the exported goods. Integrated Tax Section 3 Section 7 of Customs Tariff Act. Integrated Goods IGST levied on the goods imported into India under Section 5 of IGST. IGST is collected under Section 3 and Section 7 of CGAT and IGST is levied on such a rate not exceeding 40% of the value of imported article. Manner of computing assembling value of levying integrated tax. Value determines under Section 14 of Customs Act plus basic customs duty plus some other any other sum layable under any law for time being forced in the customs duty excluding IGST and CGST compensation charge equal to the value of layable IGST on imported goods. In the case where the imported goods are liable for anti-dumping duty and safeguard duty, the value of calculation of IGST is also included in anti-dumping duty and safeguard duty. Manner of valuing manner of computing value in case of warehoused goods. Value of levy of IGST in the case of supply of warehouse cost. Value determined by the time of filling into the bond bill of entry under section 14 of Customs Tariff Act plus bill basic customs duty 12.5% plus any other sum layable under the law of time being enforced plus 10% of BCD plus is minus CGST and SGST compensation plus or with Transaction value, sale value, whichever is higher will be computed as for the warehouse cost. Social welfare surcharge (CSWS) is important goods. Rate 10% of BCD levied and collected on the goods imported in India. Duty exclude safeguard measures, countervailing duty, anti-dumping duty, and SWS. Except integrated tax and GST compliance. Protective duty, Section 6 and 7 of Customs Tariff Act, leviable on the center government upon the recommendation made by the Traffic Commission. Its circulate exists to provide protection to Indian industry. Effective only up to and exclusively on date in which specified in the first schedule. Emergency power to impose an enhanced export duty, Section 8 of the Customs Tariff and central government imposed by amendment of second schedule by the notification. Condition goods may not be specified in second schedule. Necessary circumstances exist. The emergency power to impose enhanced import duty, Section 80 of Custom Tariff Act. The central government empowered by the amendment to the first schedule by notification. Condition the goods may be specified in the first schedule. Necessary circumstances exist. The power of the central government to apply safeguard measures, Section 8B of Customs Tariff Act, to any article imported in India into increased quality in causing it is causing or threatening the cause serious injury to domestic market. The central government, after inquiring on, can impose safeguard measure by imposing a notification in the official gazette. Mode of safeguard measures: imposition of safeguard duty or application of tariff rate, quota, or other measures as central government deemed appropriate. Duration can be 4 years, may be extended by a central government. A total period of levy of safeguard measures 10 years. Provision safeguard measures maximum period of 200 days. The exemption from the safeguard measures article from the developing countries shares import does not exceed 3% of total article originating more than one developing countries aggregate import from the developing countries each with less than 3% income import and share taken together does not exceed 9% of total import by 100% of EOQ or unit in the SEZ export of specified case. Anti-dumping duty, Section 9A of the Customs Tariff Act. Dumping is normal value of export good or export price, whichever is higher. Normal value of exported price is higher than the exported price. Anti-dumping. The computation of anti-dumping duties. Anti-dumping duty is lower of the following: injury margin or margin of dumping. Margin of dumping margin is equal to normal value minus export price. Normal value, the comparable price in which goods under the complaint are sold in a domestic market or exporting countries or territory in the ordinary case of trade. If a normal value cannot be determined as per the seal in domestic market of exporting country, normal value shall be comparable respective export price to the appropriate third country or cost of production in the country of origin, administrative, selling, or create general cost profits. Less general cost profits. Export price of article export from the exporting country or a territory. Computation of an engineering market. Engineering market is a difference between the following: landed value of a dumped article, fair selling price is equal to non-injuries price due to domestic industry. Landed value AV and the assessed value of the Customs Act and applicable BCD except special duties. Countervailing duty on subsidized article, Section 9 of Customs Tariff Act. Any country may subsidy upon manufacture, production, or exportation of article, plus such article imported in India where it's not directly from the country of manufacture or whether or not the same condition as the export from the country of manufacture. Countervailing duty on a subsidized article is imposed. Then amount of countervailing duty shall not exceed amount of subsidy paid. Common provision on the countervailing duty on the subsidy articles and anti-dumping duty. Duration 5 years, extended up to 5 years to 10 years. Circumventing of the duty by altering the description, name, composition of articles, by importing of such article into unassembled or disassembled form, by changing the country of its origin or export, levy of any other manner whereby duty of import regarding ineffective. Absorption of duty. If there is a degree of export price of article without commensurate change in the cost of production, the export price, resale price in India of such an article as case may be other specified circumstances, non-applicability of duty. Duty shall not apply to the article imported by the EOU or unit of SEZ unless it is specifically made applicable to such notification to such undertaking unit. Such article is either clearance of such into DTA or used in the manufacture of any goods that are cleared into DTA on the portion of the article so cleared or used. In the case of circumventing or absorption duty, duty can be extended, modified from such date not earlier than the date of initiation of the inquiry. No levy of Section 9 or 9 in certain cases, Section 9B of Customs Tariff Act. Both countervailing and anti-dumping duties are not levied for the same situation. Both duties are not leviable in the articles or exempt. Sole reason. Both duties are not leviable on import from the member country of the World Trade Organization or country with whom Government of India has most favored nation agreement. Provisional countervailing and anti-dumping duties are not levied on the articles import from specific countries. Appeal Section 9C of Customs Tariff Act Authority CESTAT time limit within 90 days on date of order of appeal. Type of duty computation of customs duty integrated tax payable assessable value plus basic customs duty assessable value into customs duty. Add social welfare charge on BCT 10% value of computed IGST 1 as added IGST on the yield. Total value of payable or goods and service tax compensation says Section 3, Section 9 of Customs Tariff Act. GST compensation says levied on the intra-state supply of the goods or services to provide compensation to the states for the loss of revenue due to GST implementation. Applicable only to goods or other services notified by the central government. The current levy on luxury or sin goods like palm masala, tobacco, etc. Agriculture, infrastructure and development sales was imported on certain items. Levied on the import of certain agricultural goods and smart example apple, barley, chana, ayuri, etc. So